Hello, and welcome back to Coin Lady channel. Jeremy Hogan, an attorney, has projected that Ripple will appeal the judge's decision and offers some quick commentary on the SPF trial in light of today's revelation that he will appear under oath, a somewhat precarious proposition. Even if Ripple, let's be honest, has already won not on every part of the case, it's still interesting to hear what Hogan had to say about it in the Crypto Basic in covering the bit that Hogan had to say about the lawsuit. The basic question of whether or not XRP is a security was already decided, however, and it affected not only them but every XRP holder on the darn planet. The Crypto Basic has called attorney Hogan's prediction audacious, but he stands by it. It makes sense that the waves will eventually fade away. No, we have to discuss the section where we failed, which involved sales to institutions. I also offer attorney John Deaton's take on the SPF trial for your perusal. However, I feel the need to state up front that I do not come from a financial or legal background. You do understand that I am not giving you any kind of professional advice, and that you should not buy or sell anything based on what I say, right? I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. Alright, here's the first piece of news under the banner from Crypto Fundamental Expert anticipates SEC litigation to end with Ripple prevailing on appeal across three categories of XRP sales. In the ongoing SEC versus Ripple dispute, attorney Jeremy Hogan boldly predicts that Ripple will win on appeal for all three types of XRP sales. Exciting new developments have occurred in the ongoing dispute between the SEC and Ripple in the past week. Legal experts in the cryptocurrency world have been speculating on the case's outcome following recent developments in the SEC versus Ripple lawsuit, the most stunning of which was the SEC's decision to dismiss its outstanding allegations against Ripple execs Brad Garlinghouse and Chris Larsen. Keep in mind that most XRP community members believe the SEC will either settle with Ripple or appeal to the Second Circuit. Not much has been spoken, however, regarding what Ripple might do after the verdict is in. People wonder if the SEC will be willing to negotiate after all this has been discussed. Why not? But what if Ripple just won't calm down? What if Rippling is serious about leaving to seek oversight? We're not trying to sound as punk as matches, okay? Is that really what takes place? Because, let's be honest here, when was it that this choice was made? Yes, without a doubt. We're all overjoyed by the SEC's decision that XRP is not a security. In any case, most of the analysts whose work I've read so far have concluded that anything with backing from institutions has a better chance of being approved, which is why some people believe Ripple ceased all programmatic sales at the end of 2019 at the earliest. However, they continued to offer on-demand liquidity and all related sales since they believed this strategy was more likely to pass muster in the event of legal scrutiny. In the event of a legal dispute. On the programming side of things, some speculated that Judge Torres may rule against Ripple, which might have been problematic for XRP owners depending on the final wording of the ruling. Actually, it was the other way around, institutional sales targeted squarely at Ripple. And last, the programmatic. Good. However, bear in mind that I am a fan of in the case of Ripple and their dealings, it's exactly like that. So the struggle continues. However, negotiations continue, and in an unexpected turn of events, Jeremy Hogan, an attorney, made a bold prediction about the future of crypto law in a recent interview. He stressed that Ripple will ultimately prevail in this case thanks to the blue sky defense, which will be used in an appeal to the Second Circuit. He predicted that the Second Circuit Court of Appeals would side with Ripple's blue sky defense and that, as a result, the blockchain startup will walk away, in quotes, with a huge victory in all three types of sales. Distribution could therefore be institutional, programmatic, or entirely ad hoc. And when you hear blue skies laws, just think state laws having to do with securities effectively because they predate the SEC having their Securities Act passed, as Ripple brought up in their defense as well. After years of patchwork regulation at the state level, the federal government finally passed the Securities Act. Even then, though, when it was enacted, it drew from depictions of actual laws enacted at the state level. Finally, Attorney Hogan stated that he would just like to read this last section to you. Using the blue sky defense, he calculated that Ripple had a 51.6% chance of winning the appeal. Interestingly, Attorney Hawkins' wife, who is 10 years his senior, also agreed with this prognosis. This suggests that he is likely to believe that the ripples will go into full force. Even if the SEC does file an appeal, I have no intention of changing my strategy with respect to the programmatic sales or doing anything else that could jeopardize that success. It would be fascinating if it were the case. Ripple skips the traditional conclusion and goes straight for the throat here, having secured the decisive factor. And the SEC will appeal if they feel like it. However, if the SEC does file an appeal, I believe that will just increase the likelihood that Ripple would file an appeal of the part of the judge's judgment that did not go in their favor. So, let's see how this plays out. The good news for XRP holders is that, as best as I can tell and based on what I've heard from other attorneys, this situation has been resolved and no more legal action is necessary. For example, I just saw a YouTube video featuring a group of lawyers discussing whether or not XRP constitutes a security. Moreover, even if a reasonable appeal is available, in other words, it will only have an effect on sales that involve Ripple. It would be completely irrelevant to the rest of us who trade on the market. And now we learn that after being attacked by his inner circle, attorney Jeremy Hogan penned a last-ditch SPF to testify in a fraud prosecution. The question of whether or not SBF will testify has been widely discussed in recent days and weeks. If they do, they'll be taking a huge risk. Now, this guy is so egotistical and narcissistic that he might actually think he can fool the jury into believing he is perfect and have them fall madly in love with him. I mean, I've done my share of pitching to VCs. That's something to think about. This explains his inflated sense of self-importance and narcissism. Is that really what's best for him? Since there is always the possibility that it doesn't come over if things don't go as planned or if you don't appear quite right in the standing look. If you are found guilty, you may be facing an extremely lengthy prison term, and I just have a hard time believing that SBF wouldn't be convicted, and I think he's gonna spend decades, if not his entire life, in prison. That would be my prediction. That leads me to wonder if they factor in his inevitable conviction as part of their strategy. You've got to be informing them that the chances of avoiding a conviction in this case are slim if this person is a target. They are therefore aware that he will likely spend the bulk, if not all, of his life behind bars. That's why, and this isn't what Attorney Hogan said, but it's what I was thinking when he said Hail Mary. Maybe they're hoping even in the other system, and they appreciate that it may make things far worse for him. However, there is always the remote possibility that things may go well and he will be found not guilty or given a lighter sentence than what he deserves. So they decide to just throw the dice and see what happens. I can't say. Here's the day's big story, according to Sam Bankman, the former CEO of FTX. After hearing the incriminating testimony of former co-workers, Fried chooses to testify in court. Sam Bankman, Fried, the former CEO of FTX, apparently plans to testify in court after his former co-workers spoke in a lengthy thread on X, a social networking site. Fried's attorney has reportedly told the Inner City Press that his client will testify after the fence's 3 witnesses to refute FTX employees' claims. Earlier in the trial, Fried's ex-girlfriend Caroline Ellison testified that she committed fraud at the direction of the bank's CEO, Winfrey. Between 2020 and 2022, under the supervision of Banks and Fried, Ellison Alemana allegedly stole almost $14 billion from FTC customers. She also revealed that Alameda had manipulated its financial statements to make the company appear safer to potential investors and creditors. A few days earlier, FTX co-founder Gary Wang testified against a bank when Fried, saying that the insurance fund listed by the cryptocurrency exchange was in fact a fake account. According to When the Fund, the account did not contain the $5.5 million in cash and 5 million FTT tokens, the FTX token, of course, that the exchange claimed to have in it. That's how horrible it is. Guys, they used a random number generator to convince people of all this crap. After hearing the testimony of his former employees and ex-girlfriend, it appears that SBF has decided that the best way to respond is to argue his case directly before the jury using his own words. You're going to need it, so best of luck. It's all in good fun. I don't wish him well, because I think he deserves to spend the rest of his life behind bars. After that, I'll give you Attorney Deaton's take on the situation. And the first thing I'll tell you is a secret that lawyer didn't put online. You mentioned on October 12th that the defense counsel sounds confused. When you keep reiterating the direct examination used by the prosecutor, it's because you're bored and looking for anything to do. Scoring some very specific points on cross while putting the F-bomb to rest is the way to go when precision is of the essence. If SPF doesn't take a stand, you have no chance. You score some points, and that helps you persuade one juror to stay on the fence. So, there you have it. I suppose that answers your question. Because, let's be honest, you won't be able to persuade all of the jurors to stay firm and support you. Just getting one of those isn't going to deter you, right? That's the best you can hope for if you only get one, right? The conviction would be gone, of course. So, this morning, lawyer Deaton reposted it with the following commentary. The only defense is for SPF to testify and try to persuade even just one juror that he didn't have fraudulent intent, as I mentioned a couple of weeks ago. How rapidly and ferociously it escalated. Caroline and Gary lied to save their own skins and avoid lengthy prison terms, and he just couldn't catch a break. Cross-examinations of Carolina and the others would have been considerably shorter and more concentrated if the defense attorney had been totally dedicated to this defense. I agree, there are some very perceptive observations. And we shall see what transpires. But I just don't think this is going to work out. Perhaps even his lawyers have come to this conclusion and told him, "Whoa, you're screwed." Perhaps they don't actually say this to each other, but you're pretty well doomed. Let's ascend then. Proceed to deceive the jury. So, folks, stay tuned. To be clear, I am not a professional banker. Nothing I say should influence any investments you make or decisions you make. Please like and subscribe my channel. See you later, bye.